Hey, what's up, guys? Travis Britt here with SOCEPrep.com, where you get all your resources, whether you're in a basic recruit training program or you want to transfer your certification from out of state to the beautiful state of Florida. Been down for a little while, guys. Had a little upper respiratory stuff going on. Still got some junk in my chest, so I apologize if I sound nasally, but we're going to get through this. Wanted to kick some content out because it's been too long, right? So again, check me out, www.soceprep.com, where you can get all your resources if you want to pass the SOCE. And I got something for everybody, guys. If you're broke, don't have any money, I got some free resources over there. I give away 17 pages of guided notes for absolutely free. You can use your books and you can answer those questions. It's a good free resource. I got some police encounters stuff that I give away for free. And obviously you can sign up for the email list where I kick out information to help you pass the SOCE. And obviously, like, if you want to stop wasting time, you want to get down to the beans and bullets and pass this test with ease, then sign up for one of my subscription services where I take you through and give you everything that you need. We've got weekly plans and a lifetime membership. So check me out, guys, www.soceprep.com. Check me out, check me out, check me out. Let's get to the question, enough of the plug-in, right? I got a good question last week from a student. They were asking, and I was really proud of them because they were talking about, hey, what if I'm on a tier 2? So I was like, hey, they've really been paying attention to the course because they understand the 3 types of stops. They're talking about a tier 2, an investigative stop. What do I need? Reasonable articulable suspicion. Are they free to go? No. How long can I stay with this citizen detained? A reasonable amount of time. I was taught, 20 minutes is fairly reasonable. Obviously, that can extend or shorten depending on how the interaction goes. But investigative stops, reasonable articulable suspicions led me to a point where I need to confirm or deny my suspicions and make a decision whether or not I'm going to cut bait or I am going to lean over to probable cause and make an arrest, right, or a copy of charges. So with that being said, this question says, per the United States Supreme Court, Berkemer versus McCarty, the court advised what? That student asked me, hey, I'm on a tier 2 traffic stop, and I want to ask questions about an infraction or a violation of the traffic stop, but I'm scared that I'm going to ask them to self-incriminate by asking questions about their registration. All right, and it was a good question because it does make sense, right? Because are they free to go? What are the elements where we read Miranda? We have to ask ourselves, are they free to go? And you ask yourself, if you're on a traffic stop, does it feel like you're free to go? There's blue lights flashing behind you. You're absolutely not. And if you take off, you're going to be pursued and charged with fleeing and eluding, right? Obstructing an investigation. You're going to take a ride at that point. You're going to go to jail. So you're not free to go, right? And then on top of that, you're asking them questions about something that could cost them money. They could be charged criminally, so on and so forth. How is that not custodial? So it was a good question, right? So we're going to look at this one. It says, per the United States Supreme Court's Berkemer versus McCarty, the courts advise what? So it's the United States Supreme Court case. So we know it's we know it's relevant, right? We know supremacy clause are just going to kick down to the states and the cities. So with that being said, this is what we're going off of, right? So, but obviously, also we know it went through a bunch of courts where they were confused about it, and like, how are we going to handle this? Because somebody's brought up a good point we're on a traffic stop and we're asking questions. That's a little funky, right? Are they free to go? No. Are we asking them questions that could self-incriminate? Yes. Right? So let's see how it went. Per the United States Supreme Court case, Berkemer versus McCarty, the court advised what? A says that during a custodial interrogation, when the suspect is not free to leave and is asked questions that could incriminate or self-incriminate, they should understand and waive rights afforded in the 5th and 6th Amendment, right? So we talk about 5th Amendment says what? All right, that nobody should be compelled to self-incriminate. Talks about eminent domain. Talks about double jeopardy, but in this context, I think they're talking about no self-incrimination, all right? Or you should not be compelled by the government to self-incriminate or to rat on yourself, to tell on yourself. And then the 6th Amendment is going to be like your due process rights. And I think they're referring to the fact that you could have counsel present if you're being asked questions, which, basically narrows down to what, guys? Miranda, right? So somebody's in a custodial setting and they're being asked questions, which could self-incriminate. They're not free to go. What should we do? We should always read Miranda and make sure that they're aware of the Bill of Rights, right? And those named amendments, the 5th and the 6th, and this answer choice. A pretty much explains Miranda warning, but the question did not ask us to look for Miranda warning. This is a trap, guys. They put these things in there like, hey, I know you guys are probably going to be familiar with this. Let me lay it in there so people recognize it, and they're like, oh, I know what that is, right? That's Miranda, and it just feels warm and fuzzy to them, and they pick it, right? But in the context of this question, you get yourself in trouble because they ask us about Berkemer and McCarty. All right, this is Miranda, so we're going to scratch it. It's not a good answer choice for this question. All right, good on you if you know that, right? You absolutely need to know that, but it's not relevant to Berkemer McCarty. It is relevant, but it's not the correct answer. B says that if an accused cannot afford an attorney, that one should be provided by the state. If an accused cannot afford an attorney, one should be provided by the state. That sounds like Gideon versus Wainwright. Gideon versus Wainwright was a Florida case where an individual was arrested for busting into a bar. He was a drunk, ran out of booze and alcohol. Booze and alcohol is the same thing. So he kicked the front door of a bar and sat down, started drinking off the tap. They locked him up for burglary, obviously. And he had a court date, and he showed up, and he was like, I can't afford an attorney. And they were like, well, tough luck. Today's your court date, buddy. I guess you're representing yourself, right? And he got hammered in the courtroom just like he got hammered in the bar. And they sent him off to prison, right? But he wrote the United States Supreme Court, and he got cert, right? So they said that, hey, this guy's a drunk, and he's not very sharp. But with that being said, he does have constitutional rights that should have been protected. If he couldn't afford an attorney, he should have been provided one, right? Because in the Bill of Rights, it states that you have due process rights after arrest, and you shouldn't have to navigate the legal system without some support from the government, right? If you can't afford, you're indigent, right? You're broke. So it's Gideon versus Wainwright. B is another one, guys, because it's not Berkemer versus McCarty. So we've narrowed it down to 50-50, and that's what I tell you guys to do. If you can narrow it down to 2, right, our odds of passing this test are going to be extremely high, right? Because we're flipping a coin at this point. As long as we're correct and proper up here on these 2 that we've scratched, we're looking pretty good. So C says that the amendment, or the First Amendment, does follow children into schoolhouse as long as the behavior does not disrupt the learning environment. So this is the First Amendment does follow children into the schoolhouse as long as it does not disrupt the learning environment. If you'll think back to civics, guys, should have got it in 7th grade if you grew up in Florida. That's a Tinker versus Des Moines player, right? 2 students went into a high school during the Vietnam War, had peace bands on their arms, and they were told to take them off by the principal. And they were like, why do we have to take them off? We're not bothering anybody. We First Amendment, we want to express how we feel about this war. We want peace over war, right? And the principal said, you got 2 options. You can take it off or I'm going to suspend you. They decided not to take them off. They got suspended, made its way all the way up to the United States Supreme Court. The United States Supreme Court said if it does not disrupt the learning environment, then the First Amendment applies, right? The principal should not have stepped in and tried to mold these brains to think the way he thought, right? So with that being said, as long as it does not disrupt the learning environment, then it's good to go, right? And that's changed over the years. I remember when I went to school, if you had dyed hair, that was a disruption in the classroom. They'd make you go home and dye your hair back to a natural color or shave your head, right? And nowadays you go in a schoolhouse and it looks like all kind of stuff going on in the classroom. That to me would have been distracting as a 7th grader, but it's not distracting these kids anymore, right? Nothing really distracts these kids. So with that being said, C is not a very good answer choice, so we've narrowed it down to the correct answer. Berkemer versus McCarty, that Miranda warning applies to interrogations and that routine questioning of a driver, routine questioning of a driver on a traffic stop is not considered to be an interrogation, right? So if you are working traffic, right? We're talking about non-criminal violations, moving violations, or non-moving violations for that matter. They're routine, right? So the questions that you ask, as far as that's concerned, is not considered to be an interrogation. It's not protected under the 5th Amendment, right? You're asking questions about a driver. Do you have your license? You gather biographical information to do your job, right, for the traffic stop, right? Now, are there applications where Miranda could be read on a traffic stop? Absolutely, right? Absolutely, right? So if we're doing routine questioning of a traffic stop and things start to look criminal, right? So it goes from traffic to criminal. You see this a lot in DUI, like DUI accidents for the most part, right? You show up, you didn't witness it, but then you found out, like through your investigation, you were gathering for the traffic accident, the collision, the crash. You solved a bunch of variables, and then all of a sudden you're like, man, this rascal's drunk, right? Driver number 1's drunk. So we've got to do what, guys? We've got to change hats at that point, right? And start a criminal investigation for what the driver has done, right? The violator has done, right? So at that point, you know, a very clear and uttered that you are basically changing hats, going to read Miranda, right? And make sure that they understand and waive if you're going to ask questions further from there, right? And you see it a lot in DUI because DUI attorneys are slick, but it should happen with criminal stuff as well, guys, right? We're talking about anything that's criminal. You should change hats, right? So we're traffic, right? We start working a drug and investigation. If you want to have a real tight case, you should pause, make everything safe, obviously. Read your Miranda and then go on from there, right? But a lot of these, like drug cases, you're not really going to have to ask a whole lot of roadside questions, right? Because it's going to be like plain view, immediately recognizable, so on and so forth. With that being said, guys, the correct answer on this one for Berkemer versus McCarty was D. That Miranda warnings apply to interrogations and the routine question of drivers on a traffic stop is not an interrogation, right? We're working traffic, right? Traffic is basically civil, right? We're not doing criminal investigations. It's more about money than it is anything, right? So you're working traffic. We're not talking about criminal. It's not protected. It's not considered to be an interrogation per the United States Supreme Court. Berkemer versus McCarty. D's your correct answer. Pick it. Stick it. Move on. Check me out, guys, over at SOCEPREP.com. 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 Please remember to like, comment, subscribe, so on and so forth, and pass this on to your classmates. If I'm helping you out, then it'll help them as well. Appreciate you guys' time. Hope all is well. I apologize about the delay in getting the video out. We'll try to tighten up on that here in the future. Thanks, guys. Have a good one. SOCE Prep out.